Good day, Crime Talk aficionados. We have a great show, and I'm not just saying that. First, Bryan Kohberger wants his mommy. Accused individual in Tennessee's quadruple homicide asserts his innocence. An overview of the Dan Markel murder case and Donna Adelson's trial that we're going to bring you live. Allegations service against the slain Kentucky judge regarding exploitation scheme. A teenager charged in a murder case down South Carolina. Guess what? He had a prior shooting related charges that were dismissed. We have a little bit of irony in the halls of Holiness. We have this day in legal history. We got a legal quote for you today regarding perjury and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do. Leave me a comment below, and make sure you hit that bell for notifications. And never forget, you can check us out on any of your favorite podcasting apps. Now, before we get to today's great show, let me remind you to go to CrimeTalkSearch.com. When you do, you can sign up for a background subscription service. What can you do with that service? Well, you can do a background search on anyone here in the United States. So whether it's for you personally, or maybe you're just a sleuth and you want to be able to check thousands of public records literally while you wait, well, this is for you. And when you do, you get a report that's emailed to you. It's going to have all types of background information. It's going to include phone numbers associated with the person, emails associated with the person. You're going to find out their social media presence. How about if they're married, or divorced? Do they have liens or judgments against them? Are they on a sex offender registry, along with criminal history? Everything you want to know about somebody, ladies and gentlemen, you can find out when you go to CrimeTalkSearch.com. You're going to be happy that you did. All right, let's go ahead and get to today's docket for Wednesday, August 20th, 2025. And yes, Bryan Kohberger wants his mommy. Okay, I've had lots of clients go to prison. Okay, it's just the nature of the business over the last 30 years. It's going to happen a couple of times. I know. I'm disappointed too when it happens. Well, sometimes some people deserve it, but let's be realistic. When the inmate calls and says, "Oh, they're not treating me very nicely down here," number one thing you don't want to do, complain. And two, that's kind of like having your mommy call the jail and say that you're being mistreated. Because you know what they're going to do at the jail? They're going to laugh at you, and they're going to let everybody know that that's what's going on. And basically, that's what Bryan Kohberger has done. I want my mommy to take care of it. So in a twist of irony that even the most seasoned individual might envy, Bryan Kohberger, infamous for his heinous crimes, now finds himself on the receiving ends of some unwelcome advances behind bars. That's right, the convicted killer has lodged a formal grievance alleging sexual harassment from fellow inmates, complete with vivid threats that paint a rather unflattering picture of a little prison camaraderie. Now, Kohberger, currently residing in the Idaho Maximum Security Institution's J Block in Boise, penned a heartfelt request on July 30th for an immediate change of scenery after enduring just one night in his new digs. Citing relentless verbal barbs and a general atmosphere of unrest and any participation in occasional self-flooding antics, he expressed a strong desire to bid adieu to Unit Number 2. Prison records have been reviewed, and they reveal his plea fell on somewhat deaf ears. The prison officials advised patience, noting that such disruptions are infrequent and the block typically maintains a serene demeanor. Undeterred by the initial rebuff, Kohberger escalated matters 5 days later on August 4th, submitting a detailed note to a guard. In it, he recounted alleged taunts of a particular explicit nature, including one inmate's promise of forcible intimacy and another's quip about dining preferences centered on Kohberger himself. A subsequent report from the witnessing guard acknowledged overwhelming profane exchanges aimed at the newcomer, but could not pinpoint the culprits amid all the people making remarks. So despite these claims, that's right, no transfer has materialized for Bryan Kohberger. In fact, Kohberger had specifically eyed B block as a preferable alternative, where solitary cells and restricted interactions mirror his current setup. Yet, prison notes indicate he ultimately felt secure enough to stay put in J Block, a unit blending general population with protective custody and even a few death row residents. Although it offers limited perks like daily outdoor time and bi-daily showers, a step down from his pre-conviction luxury accommodations. Now, this episode unfolds against the backdrop of Kohberger's grim legacy. Obviously, he is serving 4 life sentences following his confession to the savage stabbing deaths of the University of Idaho students, Kaylee Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin back in November of 2022. And as the wheels of justice turn slowly, it seems the confines of incarceration are proving a bit of a challenge arena for adaptation, proving that even predators can feel preyed upon in the ecosystem of the maximum security prison. Now, the Idaho Department of Corrections has yet to provide commentary on the matter. For those tracking tales of crime and consequences, such developments underscore the unpredictable undercurrents of prison life. Yes, ladies and gentlemen, you might as well have your mommy call if you are making notes saying people are being mean to you. Because if you're going to check yourself in to solitary, they're going to refer to you, I hate to say it, you're going to be a little bitch. It's not going to be pleasant for Bryan Kohberger. He has got a long way to go at being only 30 years of age, even given the average life expectancy in prison is up to about 62 years, I think. Not a huge time. Hey, another 30 years or so. You almost would have thought that maybe he'd want to go to trial, take his chances at death penalty, and be in the limelight. Now it's just kind of a watch to see what bad things happen to Bryan Kohberger. Who's going to get to him first? Is there going to be a little bit of forcible intimacy, as they say, in prison? Perhaps. Let's wait and see. Next, a quadruple homicide suspect asserts his innocence. That's right. The man charged with the murder of 4 people and the abandonment of an infant in Western Tennessee has made a public statement maintaining his innocence, by God. Austin Drummond participated in a court proceeding through video on Thursday, August 7th, and he was apprehended earlier in the month in Jackson, Tennessee, approximately 75 miles from Lake County, the site of the homicide. Well, law enforcement officials uncovered the bodies of 4 family members in Lake County on July 29th. Adriana Williams, James Matthew Wilson, Courtney Rose, and an adolescent, Braden Williams. On the same date, an infant connected to the deceased was located unharmed, abandoned in a car seat on the property of an unrelated resident in Dyer County. Investigators have established that Drummond was acquainted with the victims as he was in a relationship with the sister of Courtney Rose. Well, Drummond evaded capture for almost a week, an event that generated nationwide attention and heightened concerns in northwestern Tennessee communities. Now, in an exclusive interview with Scripps News, Drummond disclosed that he had been recruited by prosecutors to serve as a confidential informant. He asserted that he collaborated with authorities, including the FBI, in uncovering operations aimed at disrupting drug trafficking in correctional facilities. Well, Drummond acknowledged his affiliation with the Vice Lords gang, which he joined during a previous period of incarceration. He reported that in the weeks leading up to the homicides, he learned his undercover role had been compromised. Following the discovery of the murders, he fled out of fear, though he conceded that fleeing was an error. It makes you look guilty. Anyway, he emphatically denied culpability, stating he had no motive to harm the 4 individuals whom he regarded as family. However, Drummond indicated without further elaboration that he had some direct connection to the events surrounding the deaths. And when questioned about details of the killing and the circumstances under which the infant was left alive in Dyer County, Drummond declined to provide responses to those questions. Anyway, the Lake County District Attorney was informed of Drummond's statements as the interview occurred via the recorded jail telephone line, now incorporated into the case records. The district attorney refrained from addressing the specifics of Drummond's claims, but expressed absolute certainty regarding Drummond's guilt and the existence of a definitive motive. Prosecutors have indicated their intentions to pursue capital punishment in this particular matter. There you go. You always love it. You got to love it when your client's doing news interviews without you sitting next to them. Because if you were sitting next to them, well, you'd probably be committing malpractice. And now this is a statement by the defendant, and anything he says can and will be used against him. And that newspaper or news reporter will be a witness as well. Next on the docket, let's give you an overview of the Dan Markel murder case, which involves Donna Adelson's trial. The jury is just about seated. Now, we will bring you this trial once the testimony begins, and hopefully by possibly Friday. I think we should have a jury by Thursday. We'll let you know. But let's get to the story today. So more than 11 years have elapsed since the Florida State University law professor Dan Markel was fatally shot in his Tallahassee residence on July 18th, 2014. Now, Donna Adelson, who's now 75 and accused of orchestrating the crime, is scheduled to stand trial this week on charges of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. Prosecutors allege that the incident stemmed from a murder-for-hire scheme motivated by familial disputes, specifically Adelson's intent to relocate her grandchildren closer to her in South Florida amid a contentious custody battle between Markel and his ex-wife, Wendy Adelson, who is Donna's daughter. 4 individuals have already been convicted in connection with Markel's death. Donna's son, Charlie Adelson, who received a life sentence without the possibility of parole in 2023 for first-degree murder, conspiracy, and solicitation. Then we have Catherine Donna, sentenced to life without parole for her role as an intermediary. And then we got hitman Sigfredo Garcia and Luis Rivera, both serving life sentences. Now, Donna was arrested at the Miami International Airport in November of 2023, shortly after Charlie's conviction, while attempting to travel to Vietnam, where there's not an extradition treaty with the United States. Anyway, the prosecution's witness list for Donna's trial includes about 58 individuals. Now, it's unlikely that all 58 will be called, but the prosecution has to list all of those individuals so that if any of the potential jurors know of somebody, they can be identified and they can see if it's going to affect their ability to serve as a fair and impartial juror. Several names overlap with those from Charlie's trial, but a key anticipated witness, particularly those not called previously, may provide new insight into the alleged plot. Let's go through a little summary, shall we? First, obviously the defendant, Donna Adelson, as the accused, prosecutors contend she initiated the plot to eliminate Markel due to opposition to her grandchildren's relocation. And she has remained in custody since her arrest in 2023. Now, obviously, it's her decision whether she testifies or not. Then we got Charlie Adelson, a periodontist from South Florida. Charlie was convicted in 2023 for arranging the murder, allegedly to fill his mother's wishes regarding the grandchildren's proximity. Prosecutors assert he coordinated payments and logistics, and he's serving a life sentence without parole and may testify about family dynamics and communications. We got Wendy Adelson, daughter and ex-wife of the victim, involved in a bitter custody dispute with Markel at the time of his death. Wendy has not faced charges, but has been referenced in prior testimonies. The alleged motive centers on her mother's efforts to move Wendy and the children to Miami, which Markel resisted. As Charlie's sister, her testimony could address family interactions and the custody proceedings. Catherine Donna, convicted in 2022 of first-degree murder and related charges. Donna served as the connection between Adelson family and the hitmen, having an intimate romantic relationship with Charlie. She is serving life without parole and may provide details on communications and financial transactions linking the family to the crime. Then we got the attorney potentially returning, David Marcus, previously represented Charlie until shortly after his 2022 arrest. His testimony could cover early defense strategies or client discussions. little unlikely. Tara Kawas defended Magbuana in her trials, one ending in a mistrial, the other in conviction, and she may testify regarding Magbuana's statements or case-related observations. Now, new witnesses and summaries of their proposed testimonies. These individuals were listed but not called in Charlie's trial, introducing potential fresh evidence through depositions or expected testimony. Rob Adelson, estranged son, Donna's eldest son and a physician in upstate New York. Rob is estranged from the family and provided a 2024 deposition. In it, he described his mother as highly astute and self-prioritizing, unlikely to be deceived or manipulated. He referenced an instance where Donna used a racial slur and stated that she consistently placed her own interests above others. Donna's defenses sought to limit his testimony via a motion to eliminate, citing its potential prejudicial nature. Scott Radius, a family acquaintance and also a friend of Charlie, who co-invested in a Vietnamese timeshare with him. Now, Radius reportedly advised Donna on travel plans to Vietnam following Charlie's conviction. Speculation exists that he alerted authorities to her itinerary, ultimately leading to her arrest. His testimony may focus on these communications and any indications of why she was fleeing the country. Sarah Youssef, family friend, an acquaintance of Wendy prior to Markel's death. Youssef reviewed custody-related legal filings shared by Wendy. And in a recent deposition, she recounted overhearing Donna at a 2014 child's birthday party shortly after the murder, referred to Markel disparagingly as a jerk, despite his recent death, which Youssef found, well, a little inappropriate and hostile given the circumstances. Youssef expressed her belief that Donna, Charlie, and Wendy were involved in conspiring to solicit Markel's murder. Donna's defense has filed a motion to exclude that testimony. Then we got Francis Magbuana, relative of the intermediary, the brother of Catherine Magbuana. He is currently caring for her children, shared with hitman Sigfredo Garcia. His testimony could address family connections or post-conviction arrangements relevant to the plot's aftermath. So although Donna faces identical charges to Charlie and will appear before the same judge and prosecutor in the same Leon County courthouse, her trial is anticipated to, well, differ significantly. She has assembled a new defense team after her preferred attorney, Dan Rashbaum, who represented Charlie unsuccessfully, withdrew in September of 2023 due to Charlie's refusal to waive the attorney-client privilege. With extensive witness testimony and a focus on personal motives, the proceedings are going to, well, further illuminate the Adelson family's involvement in this protracted case. Next on the docket, more twists in the case of the slain Kentucky judge. And this time it involves a sexual exploitation scheme. So a woman has come forward with claims that District Judge Kevin Mullins, who was fatally shot in his chambers back in September of 2024, operated an exploitation network from his office, allegedly pressuring individuals into sexual activities in return for leniency. So Mullins, who was 54, was killed at the Letcher County Circuit Courthouse by allegedly Sheriff Sean M. Steins, a longtime associate and friend. Following the incident, multiple accounts have emerged detailing purported misconduct by the judge, including reports of inappropriate activities within his chambers, located approximately 140 miles southwest of Lexington. That would be in Whitesburg. Now, Taya Adams, who alleges she was victimized, stated in an interview that she initially encountered Mullins during his tenure as an assistant Commonwealth's attorney. She described being introduced to his acquaintances and subsequently involved in paid sexual encounters at gatherings. Now, Ms. Adams attributed her participation to intimidation, citing concerns over potential intervention by Child Protective Services and the broader judicial authority. She further asserted that Mullins and court-affiliated individuals demanded participants to maintain control, emphasizing the power imbalance where judicial decisions could impact custody or incarceration. And Adams claimed warnings were issued to ensure silence, noting a perceived normalization escalation of such behavior within the community. Well, Sarah Davis, previously employed as a deputy jailer at the Letcher County Jail, reported hearing disturbing rumors about misconduct, though she did not observe any directly. She mentioned being invited to an event that aligned with these accounts and suggested widespread local awareness. Adams' testimony represents the third public allegation of systemic abuse by Mullins, extending beyond his office. Now, she estimated that numerous individuals, including women, men, and juveniles facing legal issues, were similarly targeted. Adams admitted to personal involvement in encounters within the chambers during periods of incarceration and homelessness. And on the day of the shooting, September 19th of 2024, Mullins and Steins were observed dining together at a local establishment. Later that afternoon, Steins entered the chambers, secured the door, and fired multiple rounds at Mullins, an event that was recorded on the video. Subsequent audio evidence has highlighted further claims of favors for sex arrangement implications with court personnel. Now, Sabrina Atkins, who reported being assaulted by former Deputy Ben Fields, described witnessing sexual activities in the chambers and referenced recordings involving Fields and other officials. In a 2022 federal lawsuit, Atkins detailed being compelled into sexual acts by Fields to secure house arrest instead of jail time. The suit also faulted Steins for inadequate oversight of Fields, who later served a 6-month sentence. Legal representatives have characterized the operations as resembling an illicit enterprise within the courthouse. Now, Davis recounted instances where inmates were reportedly taken to restricted areas for unauthorized purposes with potential rewards such as privileges or other items. She anticipated that the judge's death would expose underlying corruption, possibly known to Steins. Adams suggested that the scheme persisted due to protection from authoritative figures expressing concern for future generations in the community. She described the loss of autonomy for those ensnared. Steins has acknowledged the shooting, but entered a not guilty plea to the murder, arguing for manslaughter charges based on emotional circumstances. And upon his arrest, he reportedly mentioned fears of harm to his family. Investigations have explored motives, including possible connections involving Steins' daughter, and the timeline for Steins' trial remains undetermined with ongoing evidence review. He is currently detained without bond. And I would note all these allegations of the judge's misconduct. How relevant would that be at a trial as it relates to the judge? Based upon what we know right about now, zilch, nada, nothing, never coming in, not going to happen. Unless you're going with the defense of the dead guy deserved killing, which, although interesting, is not an authorized affirmative defense under the law anywhere that I know of. So although it's interesting, makes for good, good talk, it probably not coming in at Judge Steins' trial, unless, of course, he wants it to try to say that's why he had to do it, but there'd be no defense to that. And remember, he's already made statements as it relates to why he did what he did in the evaluations that he's doing for his not guilty by reason of insanity defense, which is not going to go anywhere, ladies and gentlemen. It was a cold-blooded murder of a judge in his chambers. And even if he was running a sex ring, and I'm not saying he was, but if he was, let's just say hypothetically, you still can't go and shoot somebody like that. Anybody like that. We'll see where it goes, ladies and gentlemen. Next on the docket, a teenager charged in a murder case in South Carolina. Well, guess what? Turns out he had a prior shooting, and those charges were dismissed. Remember Devin Raper? We talked about him the other day. He's 19, and he faces murder charges in the death of a 16-year-old by the name of Trey Dean Wright, who was found with multiple gunshot wounds near Johnsonsville, South Carolina, on June 24th of this year. Police allege that Wright was drawn to a remote area on First Neck Road by his 17-year-old girlfriend, Gianna Kleistemacher, where Raper confronted and shot him amid a dispute involving a shared romantic relationship. Love triangles, ladies and gentlemen. Anyway, Raper and Kleistemacher and 7 additional teenagers have been charged in relation to the incident, with a 10th individual anticipated to turn themselves in to law enforcement shortly. 5 of those charged are being prosecuted as adults. Now, records indicate that Raper was implicated in a separate shooting incident back in August of 2024 in Conway, South Carolina, and he was accused of serving as an accessory by transporting 20-year-old Jaden Henry Brown to a location on Austin Avenue where Brown fired at a group of teenagers, injuring one in the thigh. Raper allegedly knew of Brown's intent and assisted in fleeing the scene. Both were arrested within 2 weeks. Brown later pled guilty to first-degree assault and battery in February of 2025, receiving a sentence of 5 years in a youth facility, followed by 2 years of probation. Charges against Raper were dismissed that same month. Investigators report that Raper had previously displayed a firearm to Wright and issued threats to shoot him. On the night of the incident, Wright had been spending time with friends, including swimming in a local river and dining out before staying at a residence on First Neck Road. A group of teenagers reportedly observed the confrontation, with at least one recording it on his phone. The footage allegedly captures Raper firing multiple shots, resulting in Wright's death. Kistenmacher has been charged as an accessory before the fact for her alleged role in luring Wright to the site while aware of Raper's armed intention. She is currently released on bond under home confinement. Other charged individuals include Matthew Kendall, who's 18, Sydney Marissa Kearns, who's 17, and Corin Belviso, 18. Police state that some of these individuals assisted in bringing Raper to the scene, knowing a violent encounter was likely. And under South Carolina law, the complicity forms the basis for those charges. The Florence County Sheriff attributed the shooting to a rivalry over a romantic partner, noting that the tragic outcomes for those involved. Raper is detained without bond in the Florence County Detention Center, and social media activity from Wright prior to his death suggested ongoing personal conflict and relationship issues. Now, Raper's father, Jason Raper, has a history of legal issues himself, including traffic violations, a no contest plea to criminal mischief, and drug possession. Public posts on Devin Raper's social media indicate he is the father of an infant daughter and include an image of him holding a handgun. Legal representation for Raper and the other charged teenagers has not been confirmed. Ladies and gentlemen, it just shows you, let it go. It's a girl. I know you think it's all the important things in the world. It's a girl. You're 18, 19 years old, 17. Let it go. There's lots of girls in the world. Certainly not one worth going to prison for and killing somebody for. Let it go. Next on the docket, a little irony in the halls of holiness. The timeless tale unfolds once more. Those entrusted with impairing the wisdom of the good book find themselves straying from its very commandments. In a Virginia Christian academy, the script has flipped yet again, with a teacher facing charges that would make even the most forgiving parable blush. Enter Caitlin Campbell, a 34-year-old English instructor at the C.H. Friend School, where young minds from 7th to 12th grade are molded in faith and learning. On August 14th, authorities arrested her for an alleged liaison with a minor back in November, as detailed in the police reports. Now, the specifics of the little encounter remain under wrap, leaving us to ponder whether the teenage boy involved with one of her own pupils at the private bastion of biblical values. School headmaster Dana Jones, ever the guardian of virtue, learned of the accusations last month, and without hesitation, she summoned the law and bid farewell to Campbell's tenure. In a statement laced with scripture flair, Jones proclaimed, "We opted for uprightness over concealment," quoting the holy text promise that deeds hidden in darkness will inevitably bask in the light. She added that handling the matter to the police would illuminate their institution as well, but they proceeded entrusting the probe to the professionals. Campbell now contends with grave charges, indecent liberties taken by someone in a position of authority over a child, and intercourse with a minor aged 15 or above. Now, after a stint at the Halifax County Adult Detention Center, she secured release on a quite modest $2,500 bond. Inquiries to the Commonwealth's Attorney's Office for further enlightenment on the case, well, they're underway. But one can't help but muse if only the lessons of integrity were as diligently applied in practice as they are preached from the podium there at the school. Next, this day in legal history. On August 20th, 1619, the first enslaved Africans arrived at Point Comfort in Virginia aboard a Dutch ship, making the beginning of the institutionalized slavery in the English colonies, which would be legally codified and upheld for centuries. On August 20th, 1794, the Battle of the Fallen Timbers takes place in Ohio, where U.S. forces defeat a Native American confederacy, directly leading to the Treaty of Greenville of 1795, a pivotal legal agreement ceding vast native lands to the United States. On August 20th, 1863, U.S. military commander Brigadier General Robert S. Granger legalized prostitution in Nashville in an effort to curb venereal disease among Union soldiers. A technique, apparently. On August 20th, 1866, President Andrew Johnson issued the Proclamation 157, formally declaring the end of the Civil War and the insurrection in Texas, restoring legal peace across the nation. On August 20th, 1964, President Lyndon Baines Johnson signs the Criminal Justice Act, a groundbreaking law ensuring paid legal counsel for indigent defendants in federal criminal cases, expanding the right to counsel. On August 20th, 1974, President Gerald Ford nominates Nelson Rockefeller as vice president, the first such nomination under the 25th Amendment for filling a vice presidential vacancy. Our legal quote of the day comes from William Blackstone's Commentaries on the Law, back in England, 1765 to 1769. Perjury, ladies and gentlemen. Didn't we talk about a little bit of perjury yesterday? Well, perjury is a crime committed when a lawful oath is administered in some judicial proceeding to a person who swears willfully, absolutely, and falsely in a matter material to the issue or point in question. So it has to be a material fact where the person lied, and you can prove it. Obviously, the definition underscores the essential elements of perjury: intent, falsehood, and materiality to the proceedings, influencing legal systems in many jurisdictions, including here in the United States. Next, our dumb criminal of the day. In a recognition of actions that exemplify poor judgment in criminal conduct, today's distinction goes to Stephanie Carlquist, a 31-year-old resident of Richmond, Virginia. Court records from the Madison District Court reveal that Carlquist was arrested on August 14th in connection with allegations of inflicting approximately $12,000 in damage to a vehicle co-owned by her former boyfriend and his mother. The incident reportedly spanned from July 15th to July 20th, during which Carlquist is accused of introducing salt into the vehicle's engine, dispensing glitter into the air conditioning vents, fracturing the windshield and rear view mirror, and shattering the radio display screen. These acts followed an earlier event on July 6th where she allegedly slashed one of the vehicle's tires, rendering it inoperable and stranding her ex-partner at the shared residence after a dispute. On July 20th, the vehicle was towed to a Goodyear service center for assessment, where mechanics provided the damage assessment. Evidence presented to the police includes screenshots of text messages from Carlquist in which she expressed remorse for her vandalism, attributing the behavior to stress related to her pregnancy. Additional communications, such as emails, reportedly contained offers from her to cover repair costs, provided an alternative vehicle, or even transfer ownership of her own car. Furthermore, a text message from Carlquist's father to the victim suggesting a willingness to ensure repayment and proposed resolving the matter privately to avoid, those pesky felony charges, emphasizing a desire to prevent further harm to all parties. Well, guess what? Miss Carlquist faces a charge of first-degree criminal mischief, as well as being detained at the detention center with her bond coincidentally set at $12,000. So if she posts that in cash, it'll more than likely go to restitution. Well, she is scheduled to appear in court next Monday at 9 a.m., and it serves as a reminder of the consequences that arise from impulsive actions in moments of personal conflict. Ladies and gentlemen, Miss Carlquist, you are the dumb criminal of the day. Congratulations. I don't know what was dumber, you destroying your boyfriend's and mother's car and his mother's car, or you confessing to it repeatedly. Yes, ladies and gentlemen, that is dumb. That's all we have for today. Thanks for watching. We'll see you next time. Remember, the Constitution matters.